It's now 1 month later. They have not completed their discovery, so they don't get to just make their initial filing or initial receipt of this evidence. Trump doesn't even have the discovery yet, right? So it's not a proffer. It's not very narrow, specific motion practice. It's the full case. They're not doing anything efficiently with SCOTUS. They're just trying to rush this before the election, obviously. Judge Chutkan now approving election interference from Jack Smith. We've talked here previously about how Jack Smith wants to submit a pseudo-Special Counsel report, a 180-page opening brief that's going to smear Trump with a bunch of evidence that they can't talk about during trial before the election, so they're just going to write it on paper and submit it to the public docket. And Chutkan is going to allow it to happen, even though it is quadruple the length of a regular motion filing from the government. But here is what Chutkan is enabling. It's a 6-pager out of the District of Columbia. You can see Judge Chutkan turn this one around very quickly. Tanya Chutkan, the J6 case. Jack Smith wants to submit his major opening brief. Jack Smith is completely illegitimate, not even a real prosecutor, and he's still allowed to move forward in this matter. So here is what Chutkan said. All right, Trump, guess what? As we predicted yesterday, the court will grant Jack Smith's requests to file an oversized brief on pending immunity issues. The judge says, when I got this case back from the Supreme Court, they directed this court, she bought hook, line, and sinker what Jack told her. The Supreme Court directed this court to conduct a close and fact-specific analysis of this indictment's interrelated and extensive allegations. So Chutkan is saying, well, the Supreme Court, you want a fact-based analysis like you might have in an evidentiary hearing? I'll give you a fact-based analysis. We'll just do it on paper. How about that? It anticipated that the analysis would require briefing on how to characterize numerous alleged interactions with a wide variety of state officials and private people, and supplementing other allegations with content, form, and context not contained in the indictment itself. So we need to dig into this. And so what Chutkan says, in light of Jack Smith's second draft, the superseding indictment, which he tried to fix all of the prior immunity problems in his first indictment, we unsealed that in August, and the court ordered the parties to submit briefs and factual proffers that would inform that analysis. Then on September 21st, just a few days ago, the government requested permission to exceed the 45-page limit. They called it a big, fat, comprehensive brief that included a detailed factual proffer. They're going to add in a bunch of exhibits as well. They say it's going to be of great assistance to this court in creating that robust record. But remember, Trump's defense doesn't even have all the discovery yet from this new indictment. This new indictment is a different indictment. It's the same charges, basically a different set of facts, because they deleted a bunch of the immune stuff from the original indictment. So Trump is saying, okay, you just filed this August 27th. It's now 1 month later. They have not completed their discovery, so they don't get to just make their initial filing or initial receipt of this evidence. First time Trump's going to get it is when it lands on the public docket. That feels like it's a due process problem. Now, for the second time this week, says Judge Chutkan, she's getting a little snippy here, says Trump urges reconsideration of the current pretrial schedule in a brief intended to respond to a separate issue and without fully filing a motion to that effect. And I think she's referencing Trump's omnibus that we read yesterday, saying that he's mashed too many issues in together. So Trump's argument against the limit expansion of the pages comprises a single statement, she didn't like that it was mashed in there, that the government's request would quadruple the standard page limits in the district, as we read. Now, the rest of the 9-page opposition rehashes his old positions on immunity, and that none of this should begin until he files a motion to dismiss several months from now. People are right. They're saying, well, if we're immune, then we don't need to go into this evidentiary process. In fact, going into the evidentiary process is a violation of immunity. That's what being immune gives you, is immunity from that process. So the court has already addressed the scheduling objections of Trump before, and having the government file an opening brief reflects the remand's unusual procedural posture, where the court has been directed to accept submissions and make specific determinations about the nature of the allegations, which the government modified. I think that's a little bit too on the nose. I don't think the Supreme Court said that they had to accept 180-page pseudo-Special Counsel reports. That's not what the Supreme Court said. It said it didn't need to get to the bottom of it, but they could do that via an evidentiary hearing where you have the right to cross-examine the evidence, not respond via writing in motion practice. The length and the breadth of the government's reply reflects the uniquely challenging and fact-bound nature of this. And so the brief's atypical sequence, so she knows, okay, the judge is even admitting herself, this is atypical to do this first. The order of operations is wrong here. And the size size is wrong here. It's outside of the norm. But they do serve the efficient resolution of immunity issues at the earliest stage possible. So I know that I'm really not supposed to do this, but I'm going to do it. That is reason enough to grant Jack's motion. But for completeness, however, I'll continue. The court will address Trump's new and sundry arguments about the pretrial schedule, none of which articulates a cognizable prejudice. So Trump, you're not going to be harmed at all by this big 180-pager. First, he says that the government aims to proffer their untested and biased views to the court and the public as though they're conclusive, right? It's just a big report. They're trying to try Trump in a paper filing in court docket, not in trial, which is when all the evidence is supposed to come out. But the judge says, no, allowing a brief from the government is not contrary to the law and procedure and custom. It's simply how litigation works. Each side presents arguments and proffers evidence on disputed issues. Here, whether Trump's conduct involved official acts and whether it receives immunity. And so we're here. Indeed, Trump appears to want the same approach. In fact, she went back and she dug out something where Trump's defense attorney said, Your Honor, well, how can we address this? Trump's lawyer said, well, we can make submissions. We can make necessary proffers. And said, if we're going to go the proffer route, we're certainly going to put in a record, a number of documents which we believe are incredibly exculpatory, which is just interesting because Trump's defense is not the prosecution, right? Trump doesn't have the burden of proof here. It's their burden of proof, and they're trying to present all of the evidence for the first time in a public filing. Trump doesn't even have the discovery yet, right? So it's not a proffer. It's not very narrow, specific motion practice. It's the full case. A party's factual proffer does not conclusively establish anything. It just provides evidence for the judicial fact finder to consider. It's such a sham. Now, as the court explained, allowing the government to submit an opening brief does not deny the defense an opportunity to address this. Says you can still address the issues. You're just doing it in a different sequence. There's nothing violative of due process by a government filing an opening brief and you getting a look at their arguments and a chance to respond. It's just a matter of who goes first, says the judge. And it's not that. It's much bigger than that. It's immunity prevents you from going into all of that. You have to decide the immunity stuff, and Trump's motion to dismiss, is going to be making that argument along with a bunch of other arguments. And you don't have to get into immunity. You don't have to get into the evidence of the case because it's going to be disposed of through other motions to dismiss. But she's going to open everything up and then consider the motions to dismiss later. In response, Trump's counsel reframed the problem as an election dispute, saying, Your Honor, it's incredibly unfair that they're able to put into the public record all of this at a very sensitive time in our nation's history, in the middle of an election. But Trump's concern with the political consequences does not bear on the pretrial schedule. She said, this is what Judge Chutkan said, what needs to happen before or shouldn't happen before the election is not relevant here. Don't even care about the election at all. Second, Trump asserts that there are dispositive threshold legal issues that can and should be resolved first, as we just said, including the absolute nature of immunity. Also about Mike Pence, because they brought up Mike Pence in the new indictment and he's the vice president. And the lawfulness of Jack Smith's structure, right? Jack Smith has already been dismissed by Judge Cannon. So why do we need to go into an entire 180-page discussion of the evidence if Jack Smith is not even legitimate? We don't. There is admittedly little for this court to resolve on that last question. As defense counsel acknowledges, their position runs contrary to binding DC Circuit precedent, but might be raised to preserve this issue for appeal. And so they're not going to win on the dismissal, but they'll file it. Judge Chutkan will deny it. They'll take it up on appeal. They'll deny it. They'll take that up on appeal to SCOTUS. But again, if it's dismissed, we don't need to get into the evidence of the case. Now, as for the other two threshold questions, Chutkan says, both necessarily require the very briefing that the court has ordered. In ascertaining whether any charged conduct qualifies for immunity, absolute or otherwise, the court must first determine that it qualifies as official. So similarly, the immunity determination for allegations about Pence also requires input. So I'm going to do what you want me to do in these filings. So trying to resolve those issues before the immunity briefing would put the court before the horse. The incoherence of the defense's demand, wow, so she's getting agitated here, to do so is revealed by his accusations that the current briefing schedule is highly expedited, and the Supreme Court has already criticized this. In reality, she says the Supreme Court has not criticized me. No, the schedule reflects the court's best judgment about how to comply efficiently with SCOTUS. Yeah, right. They're not doing anything efficiently with SCOTUS. They're just trying to rush this before the election, obviously. And third, Trump argues that the immunity briefing is particularly improper before we even finish discovery. Never mind that his own proposed schedule contemplated the same sequence, they say. Still, recognizing Trump's interest in obtaining lawful discovery that could bear his own arguments, the court has front-loaded discovery already. The court will rule on the pending motions to give them adequate time to review any additional discovery and incorporate it into his immunity briefing, so you can do that one later. And fourth, Trump contends that the briefing schedule will be unfair given the order about gagging Trump, because if Jack Smith submits his big, fat, disgusting motion, Trump can't respond because he's he's gagged by Chutkan. But the former contention mischaracterizes the court's order and even so identifies potential political consequences rather than legal prejudice. The court does not accept this. The court is only talking about sensitive materials, and it rejects Trump's assertion that publicly docketing non-sensitive materials would not impact or taint the jury pool. Moreover, and once again, Trump offers no reason why his own proposal would be any different. He's going to get the same materials. And lastly, Trump also claims that the government's brief violates the DOJ policy and that this would be tantamount to basically a special counsel report. He argues the brief would run afoul of the Justice Manual, which prohibits federal prosecutors from selecting the time in order to effect an election. But she says, I don't care. I don't run the Justice Department. I don't address those claims. How are those violations going to cause you legal prejudice? I don't care about the election, and I don't have any jurisdiction over the DOJ anyways. So talk to the DOJ if you're mad about them. So for these reasons, Judge Chutkan is going to allow Jack Smith, who's not even a legitimate prosecutor, according to Judge Eileen Cannon, to file a 180-page disgusting smear opening memo brief against Trump. And so thank you for subscribing and joining us as we do. This is about what we expected. And because this trial cannot happen before the election, they've got no other options. So we'll go through it. The media is going to go absolutely bananas on it once it comes out. They're going to call it the special counsel report, and we'll be here to do the job of combating their dishonesty and Jack Smith's total corruption in the creation of this fake dossier. So thanks for subscribing, my friends. We'll see you back here.